This is stuff you're not supposed to know. And this is part 5 of email questions answered by James Montgomery. He of the now defunct atgpress.com website, and I'm again still hoping maybe by the time this goes up, somebody will have put his information back online. It's vital. Singular. Almost singular, because the I-Man, the informer, has proven much the same shocking facts. Let's get going. Part 5, James Montgomery. He writes, "Hello. Well, since you know where I have come from in Patriot knowledge and where I have arrived, I won't be long. My letter to the President, January 1st, 1993, was based on several years' research. It was not so much for the secular world, but a declaration of subjection to Yeshua/Jesus Christ. It was also a declaration that I did not want to be a party to fraud. This has not changed. What changed was 5 years of further study, turning up a subject no one, to my knowledge, had seen or at least reported. The fact being, here it comes, folks, the United States is still a British colony, and that personal freedom never existed except in the minds of Americans. When I wrote the President and Congress, I believed I was free, based on what I had declared and had been taught in public school and what I had read. If you have not read my research on our being a British colony still today, you need to. Also, the Informer has an excellent book called The New History of America, which you should also read. He and I have laid out the historical facts that prove we were never free, and prove that the King of England allowed us, as a way of deception, to believe we were free in order to enslave us and use us as cannon fodder to help him colonize and make the world British. If you had read my paper, I doubt you would be using the word waver. You would have come to the same conclusions and would use instead the words change direction. The only things that have changed from my letter to the President from then to this present day is the fact that now I know no one is a sovereign in this country, and I know what to do about it. I used to claim I was a sovereign, but because of what I now know, I stand corrected. You cannot be a subject or an enemy under military occupation and claim you are a sovereign, not with any honesty and knowledge of the facts. Because we were never free from Britain, so therefore, how can we be sovereigns? Because of what Yeshua did for me, I am free in spirit, but the physical body and reality here are much different. When Yeshua's kingdom is in place, those in his kingdom will be able to say with a certainty then, we are free. Let's say, for the sake of argument, you don't accept the fact that we are still subject to England. Let's say you think this is so far back in time it doesn't matter, or your declaration to the contrary overcomes your subjection to Britain. Let's look at a more recent event in history, say just after and I'm going to put in so-called here, the so-called Civil War. The Constitution came to an end when Congress redeclared war on the South and then imposed martial rule by military occupation on the South. Through military occupation, the military removed the Republican governments from the states that were lawfully voted into office. Was not a Republican form of government guaranteed to the states by the 1787 Constitution? The same de facto Congress removed the Southern states' representatives from Congress, denying the states suffrage/representation in Congress. Since the Southern states were high contracting parties to the trust/constitution created in 1787, this voided the corporate charter. Just as it was not a lawful act for the South to cede from the Union without the consent of all the parties, it was not lawful for the corporation to continue to do business after removing lawful high contracting parties from their seats in Congress. Or how about when Congress went out of session without a date certain of reconvening? This is called sine die. If that is not enough to remove the 1787 Constitution as a valid document, including the attached Bill of Rights, how about the military commanders/generals under direction of the Congress putting in place puppet governments in the states in order to pass a new federal and state constitutions? I say Congress, not the Commander-in-Chief, because the de facto Congress overrode a lawful president's veto, effectively removing and destroying the lawful 1787 office of president. I say a new constitution because the 14th Amendment totally changed the 1787 Constitution. Don't think so? Excuse me, if you and I are sovereigns, and I wish it were so, why can't we challenge the debt the U.S. Congress creates in the United States courts? I wonder. We can't sue the government, and we do not have the right to question the debt. Let's see. Sovereign or subject? Sounds like subject to me. Or how about the fact the military occupation and declared emergency have never come to an end? Military occupation and its martial rule is not a democracy or a republic. It is a military dictatorship, with the commander-in-chief as the supreme authority of the provisional government. I am going to send an old letter I sent to a local sheriff. Read the definitions included on military occupation, conquest, martial law, and the law of the flag. Under military occupation and conquest, it is defined to be the preferred method to change as few laws as possible so as to not alarm the conquered public. I guess they know most people are ignorant of what goes on around them. Under this condition, you go and do as the commander-in-chief says, or you are locked up or killed. If, as I used to believe, God Almighty was standing ready to defeat the government on my or any other Christian's behalf, I would say, so be it, I'll go. However, God Almighty said in 1 Samuel 8, "In that day, when you cry out for me, I will not hear you." I am sure I am probably repeating some of what I said in the email to Rob, but maybe restating it will help. So in closing, I would say, show me how, as Americans, we can win a war that has been waged against us without an army. Without an army, the only other way is by guerrilla warfare, which would not be possible without public support. which absolutely would not exist. If what took place after the so-called Civil War was not bad enough, in 1933 Americans were declared enemies of the powers at be. Powers to be? Show me how. Powers that be, right? Yikes. Show me how to win this war in a court system controlled by the occupying force, when, in the new Constitution, according to the third section of the imposed 14th Amendment, judges, federal, state, and local government officials, police officers, or anyone receiving benefits/paycheck from government are prohibited from giving aid and comfort to the enemy of the occupying government. How can a judge give you a remedy when he would violate the public policy, when he has been told he will be removed from office in the very Constitution he swore to uphold and protect? So no, I do not waver. I just do not choose to fight government and God Almighty, or, at a minimum, fight government without the aid of God Almighty. I also ask you this: do not fight against God Almighty when He has declared every jot and tittle of His word will be fulfilled, and then fight a government that God Almighty is using to fulfill many of His later day prophecies. We are told how Babylon and the beast will be destroyed in the book of Revelation, and by many of the minor Old Testament prophets that deal with this subject. If change were possible, because of the slumber most of America is under, it would have to be done by education after a financial collapse, etc., etc. Just because the facts dictate this conclusion does not mean I like it, but it is the hand we have been dealt. If you have not read British Colony, Parts 1, 2, and 3, let me know and I will send them to you. Signed, James Montgomery. Here is the next email correspondence here. Hello, Lars. I have always cut right to the quick when looking or examining any subject. All you have to do in your state or any other state after the so-called Civil War is ask yourself a couple of questions. 1. Does your state constitution prohibit the possibility of leaving or seceding from the United States? 2. Does your state constitution guarantee 14th Amendment protection to its citizens? 3. Just to add another, does your state receive federal money/benefits? Keep in mind, I don't ask these questions without knowing the answers already. The answer is yes to all three. Once you determine this, then the following applies. Any state of the United States, and I point you to the definition of, that means it is under the United States' control. 1, by contract/treaty, and 2, by executive control via military occupation, as a result of the conquest which took place after the so-called Civil War. This was a political takeover by a de facto Congress which is guilty of destroying the 1787 Constitution, and a military occupation enforced by the Judge Advocate General of the Army. Now, I have made the claim that not only has the 1787 Constitution been destroyed, along with its Bill of Rights, but that the U.S. government now in place is a military government, a provisional government, as a result of the Reconstruction Acts. Yes, in existence today, not just 128 years ago, completely unnoticed by the American people. My claims, and the informer's claims, of this condition existing in this country are true. Because they are true, any state, country, I think he means county, local municipality, inhabitant, citizen with a capital C or lower c, individual, person with a capital P or lower p, resident or declared freeman or sui juris sovereign. If I left any class of living tissue out, I meant to include them also. All of these are under military control and exist for the benefit of the conquering government. You have read the facts I included in the chapter entitled Bend Over America. Oh man, that's a what a perfectly titled chapter in that book. That it's a chapter in his book, The United States is Still a British Colony. You've read the facts I've included in Bend Over America. So, when you finally understand the reality of conquest and all it entails, even though you do not see the military in the streets, nevertheless, at this time, the law of the conqueror governs. Please understand, I don't like it. I don't agree with it. But it is the truth. It is a fact. However, neither the informer nor myself are ever complacent. We always try to disprove our facts and our beliefs, for in the end your beliefs mean nothing if they are untrue. The thing is, in doing further research, we are finding more to confirm the sad but true fact of military occupation. I have obtained more proof from a government depository library in the Congressional Record on this subject. I have not yet had time to read all that I have copied or transcribe it, but here are a few samples. The following quote is from Congressman Ross, January 26, 1867. Quote, "If the southern states are conquered provinces, then by the laws of nations we are responsible for all the debts and liabilities of the conquered country. I ask, gentlemen, to pause before we take so great a responsibility as this upon us." Wow, that was from a Congressman Ross in 1867. Here's another congressman's quote. Congressman Cullum from a couple days later, January 28th, same year, 1867. Quote, "Republican in form, governments formed by the chief executive without authority of law, and upheld by the military power when deemed proper, and set aside at the suggestion of post-commanders of military districts, these state governments, conceived in ignorance, brought forth in confusion, and rocked in the cradle of treason, are to be palmed upon the country as legitimate, and taken into the sisterhood of states as republican in form, with all the rights belonging to great states of the Union." Unquote. What a damning quote by Congressman Cullum, 1867. Montgomery writes, "This is a quote from the SOB responsible for writing and seeing to the passage of the Reconstruction Acts. The Republican majority leader, Mr. Stevens from Pennsylvania. Of course, it is not hard to be the majority when you have removed your opposition." The following is from this Congressman Stevens who wrote the Reconstruction Acts. Quote, and it's from February 7th, 1867. "Nearly 2 years ago, the armies of a government calling itself the Confederate States of America were conquered, and the government was dispersed. By the law of nations, the conqueror after that had a right to say exactly what government should be administered over them or by them. keeping always within the law of nations. The conqueror had a right either to extend his own laws over those conquered states, or if no action was taken by the conqueror, then by the law of nations the old institutions were permitted to run on for the purpose of administering the local laws until such time as the conquering party should act. This bill provides the 10 disorganized states shall be divided into 5 military districts, and that the commander of the army shall take charge of them through his lieutenants as governors, or you may call them commandants if you choose, not below the grade of brigadiers, who shall have the general supervision of the peace, quiet, and protection of the people, loyal and disloyal, who reside within those precincts, and that do so he may use, as the law of nations would authorize him to do, the legal tribunals wherever he may deem them competent. But they are to be considered of no validity per se, of no intrinsic force, no force in consequence of their origin, the question being wholly within the power of the conqueror, and to remain until that conqueror shall permanently supply their place with something else. Unquote. That again from Congressman Stevens of Pennsylvania in early February of 1867. Yeah, that was the SOB who wrote the Reconstruction Acts. The following quote is from a Congressman LeBlond on the same day, February 7th, 1867. Quote, I feel, sir, that the passage of this bill is the death knell of civil liberty, not only here but everywhere. Sad as the thought may be, it is too true that almost the last hope of a once free people, that liberty is secure here, is fast passing away. The bill under consideration proposes to establish nothing more and nothing less than a military despotism. The provisions of this bill strike down every important provision in your Constitution. You have already inaugurated enough here to destroy any government that was ever founded. When you do that, there is nothing left, I repeat, nothing but quiet submission to your tyranny, or a resort to arms on the part of the American people to defend themselves. We are drifting to monarchy. It will come unless the people take this matter in hand and stop this progress that is being made in the downward road, and restore this shattered government upon the basis upon which it was originally founded. Unquote. That quote again from Congressman LeBlond, February 7th, 1867. The following quote is from Congressman Raymond, February 8th, 1867. Quote, man, I'm running out of inflections I can do. Quote, will it aid the cause of democratic government to exhibit this great republic, this model, as we have sought to make it, of what every republic should be, abandoning all the functions of civil government, abrogating everything like civil authority over 1/3 of our domain and 1/3 of our people, and for very imbecility and inability to agree upon any measure, handing over the control of this section and these people to the absolute and sovereign will of a brigadier general in the regular army? Will that aid the cause of free republican government anywhere on the face of the earth? It is the last resort of a decayed and dying republic. If we have no better resource than this, we may as well do at once what this would seem to be a preliminary step for doing. Invite the regular army to take control of the whole country. install itself here in the capital as the central sovereign power and make such laws and issue such decrees as it may see fit." Unquote. That one again from Congressman Raymond, February 8th, 1867. The following quote is from a Congressman Harding, February 12th, 1867. Quote, "Now, I again call on gentlemen who deny that the Union has been dissolved, for I suppose this military bill is to pass, if any does, to pause before they take this last and final step. What does this bill do? It proclaims the Union dissolved. It declares the 10 states are out of the Union. And if 10 states are out, all are out. The Constitution holds and binds all together, or it holds none. It proclaims that the Union is dissolved, that the experiment of man's capacity for self-government is a failure, and yet, gentlemen, are disposed to rush madly upon the passage of a bill declaring in substance that the Union is dissolved, establishing an absolute military despotism over 10 states, with a population of 8 or 10 million people, giving to the military commander unlimited and absolute power over life, liberty, property, and all things else." Another quote from Congressman Harding here. "As the gentleman from Pennsylvania is now in his seat, I will repeat a remark which I made a short time ago when he was absent. I said that he was the first to make the startling announcement here in this House a few years ago that all compacts between the North and South were abrogated, and that the laws of nations and of war thenceforward controlled the destinies of each party in the conflict then pending." Unquote. Again, those quotes were from a Congressman Harding, February 12, 1867. What revealing quotes these are. Wow. Why have these been excised from history? From mainstream American history. The following quote is from a Congressman Eldridge, February 7th, 1867. Quote, "It is true, undoubtedly true, that these states remain disorganized states in the Union. It is also undoubtedly true that those who were the conquerors upon the field of battle reduced those in rebellion to subjects." Unquote. Again, that quote from Congressman Eldridge, February 7th, 1867. Now the words of James Montgomery again. "You see, under military occupation, as defined by the law of nations governing the fighting of wars and conquest," and also read the Lieber Code / General Order 100, which I included in Bend Over America. In that, the conquering government leaves as many laws of the conquered government in place, and over them sets provisional governments to rule the public. The conquering government can also transfer the military governance of the public to the civil authority, which they have set up as a provisional government. The governing authority over the conquered land was transferred to the Attorney General under the direction of the Commander-in-Chief. Title V is the codified rules for the provisional government, just as a matter of deduction. Here are a few more examples. The following quote is from a Congressional Globe concerning House Resolution 1328. Quote, "The following bureaus shall be established in this department," the Department of Justice, a Bureau of International Law, a Bureau of Revenue Law, a Bureau of Military and Naval Law, a Bureau of Postal Law, a Bureau of Land Management Law," unquote. The following quote is from a Congressman Lawrence. Let's see. Quote, "This bill, however, does transfer to the Law Department, or the Department of Justice, as it is now called, the cognizance of all subjects of martial law, and cognizance of all subjects of military and naval law, except that portion of the administration of military justice which relates to military court-martial, their proceedings, and the supervision of records," unquote. Here is Congressman Lawrence again, quote, "If a question of martial law is to be determined by the law officers of government, it will now belong to the Attorney General, or to this Department of Justice. It will not belong to the Judge Advocate General of the Army. He will not be called upon for any opinion relating to martial law or military law, except as to that portion of the administration of military law which relates to military justice," unquote. Again, Congressman Lawrence, quote, "In other words, the Judge Advocate General, instead of giving legal opinions to the states of the Union, their right to call upon the government for military protection or military aid, and other grave constitutional questions will be limited," unquote. Again, Congressman Lawrence, quote, "The 8th section provides that the Attorney General is hereby empowered to make all necessary rules and regulations for the government," unquote. Quote again, "The 11th section provides that all monies hereafter drawn out of the Treasury upon requisition of the Attorney General shall be dispersed by such one of the clerks herein provided for the Attorney General as he may designate, and so much of the 1st section of the Act making appropriations passed March 3rd, 1859, as provides that money drawn out of the Treasury upon requisition of the Attorney General shall be dispersed by such dispersing officer as the Secretary of the Treasury is hereby repealed," unquote. Quote again, "The 15th section provides that the supervisory powers now exercised by the Secretary of the Interior over the accounts of the district attorneys, marshals, clerks, and other officers of the courts of the United States shall be exercised by the Attorney General," unquote. Those were all excerpts from a Congressman Lawrence speaking about House Resolution 1328. The following quote is from Congressman Harding, February 12, 1867, again, quote, "Now look at what has been done. That very party obtained control of the government. There has been war. That war is over. But the Union is not restored. And at this very moment the public debt, mountain high, is casting its deadly and blighting shadow of bankruptcy over the whole country. We are literally bankrupt today, and generations to come must be ground to the earth under the crushing weight of this monstrous debt," unquote. That quote again was from Congressman Harding, February 12, 1867. The following quote is from Congressman Elliott, February 11, 1867. Quote, "Section 13, be it further enacted that all laws now in force in Louisiana, consistent with the Constitution and the laws of the United States, and with the provisions of this Act, shall remain in force until repealed or modified, provide that no person shall be competent to act as a juror who is not an elector under the provisions of this act, and provided also that all the expenses of and incident to the administration of the provisional governments herein provided for shall be collected and paid as is now done for the support of the present government of Louisiana. Unquote. That from a Congressman Elliott, February 11th, 1867. One last little blurb here from James Montgomery that will conclude this particular email. We have one or two more we're going to get to for the show. This should drive home the painful truth the informer and I have been writing about for some time. I know it is hard for some to accept because it removes so many supposed remedies and the hope of the 1787 Constitution ever coming to our rescue. I wish it were so. However, the overwhelming evidence cannot, I repeat, cannot be rebutted. Signed, James Montgomery. Next email. Al, notice by these documents that lawful money was demanded. The king granted the land to the proprietors, and it was later given back to the king. Also notice one of the proprietors was Chancellor of the Exchequer, and that the land and the minerals was granted to them and returned to the king, proving the minerals would have to been granted to the states, would have been granted to the states, in the 1783 Paris Peace Treaty. I hope others can read this and understand just as we have been telling them, we continue to pay the king his annual 30%, and as the contract of 1782 makes clear, includes loaned money to the U.S. Ask yourself, why would a country that was supposedly defeated and run out of a country, which it loaned money to the belligerents, within a couple of years of the conflict? Man, that's garbled syntax there. If others have any knowledge of interest/usury and how it conquerors, more garbled syntax, they will understand what we have been telling them for a couple of years now. Signed, James. Oh boy. And now it includes a couple of extraordinarily long contracts from the founding of a couple of the colonies in New England. I'm going to skip over these. Holy smokes. They're from 1674, and wow, are they ever voluminous. I don't even see any punctuation other than commas. Holy smokes. It goes on. Oh boy. This second page. Third page. Boy, these lawyers. Oh my gosh. Next page, it's just complete wall-to-wall text with no periods. The best you can hope for is a semicolon here and there. Other than that, you got a lot of commas and the words just go on, and titles of nobility. Same with the next page. Hiding the keys of knowledge, obstructing the pathways of knowledge, obfuscating what lawyers do best, all of it, just as the Lord said. Okay, this looks to be several pages of proofs that James Montgomery included. Many pages, actually. Let me get through here. Are we at the end? We might be at the end, folks. This looks like, well, let me just read a couple of little excerpts here. Oh no. Finally, we get back to some text from Montgomery himself, these emails. Another email. A Bill D. Bradley wrote, "This is how the corporate states own property, and you don't, and why they charge you a rent roll tax, which you call a property tax. You have to read this a couple of times, and know the laws of mortmain, as do James and I. Good work, Joyce. Signed, Big Al. Joyce, and now I think we're getting to James Montgomery here. Joyce, this whole case is summed up in the last paragraph. The court ruled mortmain does not exist in this country. On its face, it would appear to contradict what the informer and I have been saying, but au contraire. There are some very interesting and deceptive truths that can be taken from this case. I first read this case a few years ago when researching my A Country Defeated in Victory. The English statutes of mortmain were never in force in the English colonies, and if they were ever considered to be so, in the state of Ohio it must have been from that resolution by the governor and judges in her territorial condition, and if so, they were repealed by the Act of 1806. If it is as the court ruled, that is, that there is, nor never has been, the right of mortmain in this country, then Americans need to wake up to the truth of what the informer and I have been saying. Let's examine a quote from Jefferson that I have in my research paper called A Country Defeated in Victory. On February 15th, 1791, Jefferson wrote Washington to tell him his objections of the establishment of a national bank. The bill for establishing a national bank undertakes, among other things, is this Montgomery writing this, or is this Jefferson? I don't know. There are no quotes. 1. To form the subscribers into a, you guessed it, corporation. 2. To enable them in their corporate capacities to receive grants of land, and so far as against the laws of mortmain. 3. To make alien subscribers capable of holding lands, and so far is against the laws of alienage. 4. To transmit these lands on the death of a proprietor to a certain line of successors, and so far changes the course of descents. More garbled syntax. So we need a proofreader. 5. To put the lands out of the reach of forfeiture or escheat, and so far is, does he mean so far as? And so far as is against the laws of forfeiture and escheat. I don't know. 6. To transmit personal chattels to successors in a certain line, and so far is against the laws of distribution. 7. To give them the sole and exclusive right of banking under the national authority, and so far is against the laws of monopoly. 8. To communicate to them a power to make laws paramount to the laws of the states, for so they must be construed, to protect the institutions from the control of the state legislatures, and so probably they will be construed. I consider the foundation of the Constitution as laid on this ground, that these are the words of Jefferson, I guess, that all powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states or to the people. Unquote. To take a single step, is this still Jefferson? There are no quotes, I can't tell. To take a single step beyond the boundaries thus specially drawn around the powers of Congress is to take possession of a boundless field of power, no longer susceptible of any definition. The incorporation of a bank and the powers assumed by this bill have not, in my opinion, been delegated to the United States by the Constitution. So I think we're still dealing with the words of Jefferson here, and I think there's a little bit more here. Yeah. Can it be thought that the Constitution intended that for a shade or two of convenience, more or less, Congress should be authorized to break down the most ancient and fundamental laws of the several states, such as those against mortmain, the laws of alienage, the rules of descent, the acts of distribution, the laws of escheat and forfeiture, the laws of monopoly," unquote. Back to Montgomery's words. Clearly, Jefferson was of the opinion that the law of mortmain was in effect in the states. The only way you can use the law of mortmain on your behalf and require a corporation to obtain a license from you or reject its incorporation, because the corporation would consume your land without your being able to own it again. The only way you can do all that is for you to be sovereign. Jefferson believed he, the states, or at least the U.S. government, had the power of mortmain. So we have a dilemma here. Who is right, the court or Jefferson? The court was right. Mortmain never existed in this country. Everybody says Jefferson was so smart, but man, I come across so much these days of how he seemed to be the least in the loop. For such a smart man, he seemed to be so out of the loop to be in that circle of power, being one of those founding elitists who set up the United States. He nevertheless, I mean, the other lawyers hid a lot of stuff from Jefferson, it seems. The court was right. Mortmain never existed in this country, meaning the power, sovereignty to use it. Jefferson assumed, maybe that is too harsh of a word, he believed, as a result of his extensive legal training through his command of 5 languages, that he was a free man and had the power to demand any corporation had to obtain a license to become a corporation. Under mortmain, the corporation, in this case the bank, was illegal, because this nation's land would fall into dead hands as a result of interest and fiat money. Jefferson also argued that the bank would also violate several long-standing laws common to Anglo-Saxons. Based on the information the informer and I have published, the court was right. You see, freedom, sovereignty, and mortmain are synonymous. If you don't have the power to execute mortmain, you are neither free nor sovereign. The court was boldly telling America the truth, a truth we are now aware of. The Revolutionary War never changed the King's Corporation, America Incorporated. Knowing Washington's honor and will to do right, Hamilton had no problem in convincing Washington to allow the incorporation of the bank into this country. Washington's personality and honor were well known. All Hamilton had to do was show Washington the legal title through the charters and the trust, and Washington would be forced to allow the bank to increase the king's holdings so he and his heirs would enjoy the fruits of the king's investment. In spite of Jefferson's on-point arguments against it, the bank was incorporated. Look at the outcome just in 207 years. So what was it Jefferson misunderstood? He did not understand that the war was not enough to overturn the king's holdings and corporations. He did not understand conquest. The only way we could have gotten the land above and below ground was to allow the 6th article of the 1783 peace treaty or the 9th article of the 1794 treaty to be included, or we would had to go and defeat England on their soil, conquest them, in other words. If the two above-mentioned articles had been left out, the Revolutionary War would not have stopped, nor would the king have pulled out his troops from Washington, D.C. during the War of 1812. So, you see, the court was telling us early on, along with other decisions, that we were still subject to England, as far as being contributors to the king's commercial enterprise, because, any way you cut it, we were enjoying a benefit that the king provided, because we would not be here if not for the king's commercial venture. This is why the courts ruled in this manner. Signed, James. All right, this concludes part 5 of your email questions answered by James Montgomery. This has been stuff you're not supposed to know.